Welcome everyone to another session of Litigators Corner, a series put on by the Beverly Hills Bar Association. I'm Rudy LEHRER, a member of the Litigation Executive Committee and principal of LEHRER Law here in Beverly Hills. Today I have the distinct pleasure of interviewing David Anderson regarding tax concepts often overlooked by general practice litigators, especially deductibility of legal fees. I met Dave several years ago through my prior practice as a partner with another Beverly Hills firm. I was immediately impressed with his wealth of knowledge of tax law and his distinguished career. Dave is a tremendous resource, not only to me, but to numerous other attorneys and the national practice. Now, a little bit about Dave. I want to brag about his background. Dave is a graduate of Yale College and the University of Chicago Law School. After school, he served as captain in the Air Force General Counsel's Office in the Pentagon. Following his service, Dave joined the prominent DC tax firm of Kaplan and Drysdale. Life led Dave to relocate to California, where he practiced with other prominent firms, including Loeb & Loeb. Dave has received the LA County Bar Association's Dana Latham Award for lifetime tax law achievement, and he's been recognized in Best Lawyers in America for over 2 decades. Dave has numerous publications. He's taught at USC, UCLA, and Harvard Law School. He also serves on the planning committee for the USC Tax Institute. Dave, welcome.
Thank you. Thank you for asking me.
Now, tell us a little bit about your current practice.
Well, I work on tax stuff, as you might imagine. I happen to be working on U.S. tax aspects of the biggest tax fraud case ever, where people took $70 billion out of the German and Dutch and Belgian national treasuries, and thus creating, on the side, significant U.S. tax issues.
Wow. And in terms of your other cases that you're working on, can you tell us, at least in general terms, the issues that are presented typically?
Well, the issues that I work with Steve Mather a great deal. We have a partnership, and we wind up cleaning up messes, basically. And, you know, that puts you in the cynical position of seeing when things have gone wrong. But as an example, we currently have a case in litigation involving a bankruptcy in which a big New York investment bank stuck our little guy clients with $60 million of cancellation of debt income, and with a completely false return. And we managed to persuade the IRS of that, and now we're trying to recover with the IRS's help from what would otherwise be a bankruptcy-inducing event themselves for the individuals.
Wow. So you raise a good point about cleaning up messes. When we talked before this call, a lot of times it's just out of sight, out of mind for general practitioners regarding tax issues, particularly for the client. I know most attorneys encourage the clients to contact their accountant. Please take into account that they're not giving tax advice. Tax lawyers give proper tax advice, but I think it's good for general practice litigators to have some sense of some of the concepts that they should be aware of, whether they're planning for settlement or appeal. I know you've mentioned to me there are a number of situations that tax consideration in advance would be helpful. Go ahead.
Well, yeah, I have some favorite examples. Just as a sort of a gross outline, if somebody recovers, a contingent fee lawyer recovers $100 for a client and takes 50%, having gone to trial, it could be that the client winds up with nothing, because after the 2017 Tax Act, many legal fees are not deductible. So the client pays tax on $100, winds up with $50 after tax if it's a big amount, and can't deduct the payment to the lawyer. So that's 50 plus 50 is 0. Clients become very unhappy when they realize that. And one thing that I find over time is that litigators in their engagement letters often don't say whether they give tax advice or not, which they really ought to say they don't, unless they call in a tax lawyer to work on it. On a more cheerful side, there are a lot of circumstances where you can really change things for the better with taxes. And one of my favorite examples is a hospital technician who worked closely with doctors and patients and was HIV positive. And the doctors and patients and other techs really didn't like that. They didn't like being around this potential risk a lot, and they really mistreated him. He moved, and so he quit and sued, and they settled on $250,000, but he wasn't willing to accept the settlement unless it was tax-free. And you might know that legal recoveries are taxable unless they involve physical injury or actual disease. I happened to talk to the lawyer handling the case, and I said, gee, why isn't this guy, I wonder how this stress affects this guy. And he said, well, that's actually our problem, because the doctors at the hospital think that the stress moved this guy from HIV positive to actual AIDS. And I said, there you go. He's got an actual disease and it's tax-free. But they were stuck, unable to settle the case. So tax lawyers helped.
That's very interesting. Are there other situations, if be it in also in employment or in real estate, where if there's some thought given to how you're characterizing the payment, it would have tax implications?
Well, it happens all the time. Let's say an employment case. Typically, when you settle an employment case and you get lost wages, you have to withhold taxes from it. On the other hand, if you're able to, let's say you have somebody, and I'm familiar with a case like this, that had a fancy job at a big corporation and got fired for bad reasons, refusing to go along with things that you shouldn't go along with. And the defendant corporation really wanted the settlement agreement to say that you were never going to say anything about why you got fired. And the result was that lawyer was basically prevented from going back into big firm practice because, here you got fired and you can't even say anything about why. And so I managed to characterize the result of the case as a sale of your professional goodwill. You were never going to be able to go back to big firm and have the present value, which divorce lawyers are able to value. What's the benefit of being a partner at a big law firm? And so we were able to say that that's capital gain, which closed a big gap in the settlement process. And then we structured it as a payment over time, which led to lower average tax rates and a significant net present value increase. So, that case got settled in a really favorable way, which would not have happened otherwise.
Yes, and being creative. I know you even mentioned in that's one case where it's high stakes in the corporate arena. Then even with in real estate landlord-tenant situation, I recall you had a situation where just being creative about how those payments were made for a small-time litigant worked out. You can tell us about that one.
That was fun because the firm was representing the son of a very important client, not a case the firm would have taken, and who had been greatly disadvantaged in the client's view from having water leaking through the ceiling in his fancy apartment. And they agreed on a $50,000 settlement, but he would only take it if it was tax-free. And so, it was pain and suffering. Clearly, it wasn't going to be tax-free. So I said, well, geez, how much rent did he pay during this period when he was the apartment was made less valuable to him? And they said, well, $130,000. And I said, well, why don't you characterize what happened as a refund of $50,000 of rent, which being personal rent was non-deductible and therefore non-taxable. And, that's how it worked.
That's interesting. And now, considering the economic events, a lot of people are well, at least in our area, are now contemplating bankruptcy issues. And I know that you also have cases where being aware of tax implications and the mechanics of the bankruptcy process would be advantageous in advance. Are there one or two situations that you can kind of explain where you should be wary of how you proceed in the bankruptcy courts?
Well, there are a lot of technical issues, like you can't discharge IRS debts in bankruptcy unless they're more than X months old. Maybe it's a year or 2 years, so you got to be very cautious about that. But basically, when you're in bankruptcy, it's the Wild West. You need to really have your wits about you and watch out for what people do to you. An example which I worked on for quite a while is a bankruptcy where deferred compensation by a number of executives was wiped out. And they had a lawsuit as a result of the leverage buyout that preceded the bankruptcy that said that the shareholders got money they shouldn't have gotten, and these executives should be able to get it back. And the very weird ending of the bankruptcy was to transfer those claims to the executive on the first day of that the corporation exited bankruptcy. And that corporation took a big deduction for the value of those claims that were transferred to the executives as if it was compensation. And the value was absurdly high. It was like 4 times what they ever collected, and certainly not a present value. But they sent a W-2 to these people, and they thought, oh, we have to pay tax on this income. And, that was kind of a disaster, which got partially repealed when eventually they consulted a tax lawyer and figured out what had gone wrong. So you just have to watch yourself.
Yes, and particularly in the Wild West of bankruptcy. I believe there was other, you had mentioned there was the goodwill was one really creative example. Are there others in terms of business disputes that you note or you think our viewers should be aware of?
Let me give you one that I'm particularly fond of. There was a partnership in a creative enterprise, and the principal partner had offered the creative person 40% of the profits in the partnership to become an actual literal partner. For whatever reason, this creative partner turned it down. Then the company got sold for $15 million, and the creative partner then said, well, that's just outrageous. I should have gotten 40% of that. And then sued, and was in some way had a good chance of winning, but again insisted on, I think in this case, $8 million, and the client was only willing to pay $5 million. We managed to say that this looks like this creative partner is actually selling a partnership interest back to the principal partner, and that looks like a capital gain. So let's see if the creative partner's tax accountant will agree to report it as capital gain. And they agreed, and the case settled on the lower number, but a higher value to the creative partner.
Wow. And also just to put it in context too, because for those that haven't really looked at the tax issues for deductibility of legal fees, I guess if kind of a crude timeline is, I think, or for people, the uninitiated, including myself, where you just assume, okay, any fees incurred towards producing income you can deduct. It seems like was it the mid-90s was kind of the first milestone where the regulations were starting to create a test for what was going to be deductible in terms of the proceeds and the legal fees incurred. And then obviously we have the recent change in the law in 2017. What should our viewers be aware of in terms of what was the law, what's changed, and what may change back in terms of tax issues?
Well, first of all, there's an obvious chance that the administration will change and the extremely low tax rates will go away. And perhaps with those, some of the little goodies that they took away to justify the extremely low tax rates. The biggest one, as I mentioned before, is that in 2017, they said that legal expenses of producing income are not deductible. That's the miscellaneous itemized deduction expense. And I think from a litigator's point of view, it's seriously important to consider what their clients think when they take on a case, because if the client thinks that they're going to be able to deduct the legal fees and then they aren't, you can see that can easily change the after-tax result by 50%. And I'll give you another example. A commercial litigator in Los Angeles brought a big case saying that there's a big commercial litigation case and settled it for X dollars, good settlement, and then got sued by the clients for not exploring doing a structured settlement. That is a payment over time which could advantage the clients. So that's the example of how you have to really protect yourself as a litigator settling a case. You need to ask for tax advice. And if you come up with a bad result, you also ought to say to yourself, hey, maybe it's possible to dig down another layer and change the sign of the answer, which I think is often the case.
Well, and it is, and I think I recall you explaining too. Sometimes it can be a very amicable settlement. There's a lot of traction to get a deal done, but unfortunately, parties are both laboring under different assumptions. Who's going to pay the taxes and what's being withheld, and whether one party is going to pay them, or whether while the payor is going to just go ahead and withhold them as if they were wages. And that's one consideration. I don't know if you can speak to if there are certain unique examples you have where the parties were both under the wrong assumptions until the very end, or were able to correct it at the outset and say, well, here are the numbers and what the goal we have to work towards.
Well, let me, if you can still hear me over the rain, let me give you an example. People settle an employment dispute and they're going to pay X dollars. They say nothing about taxes, and then when the employee gets the payment minus the withheld taxes, they're horrified. Or, separate result, they say that we will withhold taxes, but it's not clear who that's charged to, the employer or the employee. And so they get into a dispute about that. And the worst aspect of that is that a judge may say, well, you really never had a meeting of minds, so your settlement is invalid.
Right, if it's a material term. One other, we were talking about settlement, but then one consideration that I thought was excellent that you had noted was in terms of decisions to appeal and taking into account an appeal is by no means an immediate process, and there's the labor of the briefing, the appellate docket, and time. And if you could speak to that for litigators, particularly those that are contemplating appeals and counseling their clients about the results, what should they take into account from a tax perspective?
Well, typically, if you're appealing a verdict, you can't deduct it. So let's say your choice is to pay right now or to pay 4 years from now at a reduced amount. If you, like many fancy clients, your cost of capital is 20%, you may be better off to pay the whole thing right now, but you at least have to think about it. And then once you get into that discussion, you can explore the possibility of setting up a trust account to an escrow account to cover the litigation. And under some circumstances, that gives you an upfront deduction, even though you can continue to litigate. So that can make a huge difference in the net present value of the loss to the client. But you just have to do it.
Is there any other tax issues on the horizon? You say there could be, we just went under a huge change in the law, and now, given us uncertain times and maybe with the political situation and who prevails at the end of the year, we may be encountering a different change in the law or a return. The provisions, as I understand, that were changed in 2017, relevant to this discussion, sunset, I believe, what, in 2025. But that we should not assume that would be the case. That may sunset earlier, or we may be doing a U-turn earlier. What can you speak to that as well, and how people should proceed?
Well, one important thing is that the rates may go up a lot because they're at quite a low rate, especially for capital gains. The California legislature has introduced a bill to add 3 percentage points to the highest income, over 5 million. So if you have some very large recovery in prospect, you might be better off to take 4 million today than 6 million 2 years from now if you live in California. You need to think about that. And if you're deferring a settlement, a structured settlement, bear in mind that the 2026 tax rate may be a lot higher. It might go for capital gains from 28% to 38 or 40%. Ordinary income could easily be over 50. So you have to take that possibility into account, just like on the defense side, you worry about when you get to deduct it. You may, as a defendant, want to wait 4 years to deduct it. we'll know more in a few months, but that's up there.
It's clearly an important consideration where litigators now are weighing when they will get in front of a jury, or if they have the bench trial. Clearly, we're in a new area, and we have yet to see, but that should factor into that analysis, and I think will be very helpful for our viewers.
I had one more. I'm not sure we talked about this, about the German withholding tax.
No, I don't think in particular.
Well, let me mention it because it was particularly fun for me. Some litigators were defending a multi-billion-dollar claim by German nationals against a German corporation, and the case had been brought in California for what some would say are bad reasons, but they thought they'd get a bigger payment here. And the litigators lost a $300 million judgment, and then they appealed, and they were very happy to settle for $150 million on the appeal. And then when they settled, there was a lot of really happy talk in the elevator lobby about they had this great settlement. And I said, I happened to run into them, and I knew just enough to ask the following question. Well, who's going to pay the German withholding tax on the payments to the Germans? 30% withholding tax from this U.S. subsidiary. And there was like shocked silence. And there was months of straightening it out, and they finally straightened it out, which is another lesson that you can fix it sometimes. But if I hadn't run into them in the elevator lobby, it might have just dissolved into disaster.
Dave, thank you for taking the time to speak with us. I understand that you are broadcasting from outside of California in a beautiful part of the country. If you could just tell us where you are.
Well, I'm in Gallatin Gateway, Montana, where we were skiing in Big Sky on March 16th when the music stopped. And then it didn't seem obvious that we should leave our nice house up here and go back to crowded Southern California. And that judgment seems to be supported every week, and so here I am still.
No, it's clear and I've always been impressed with your background, knowledge in tax law, and that you have fun doing it. I can speak for other attorneys and my partners that we really enjoyed your insight and creativity and the challenge that you seem to be inspired by it. Is there anything else that you think our viewers should take into account? Or is there a way to consult any of your publications for further guidance or that you'd recommend?
Well, we got started talking about this because I wrote an article called Tax Adventures in Litigation Land, which is 10 or 15 examples. And if somebody would like to get a copy, I'm happy to mail them one. I'm at cda@cdavidanderson.com.
And we'll provide your contact information too in the comments below. So
the other thing is that I'm not sure I would encourage somebody to become a tax lawyer anymore because it is so complicated. It just drives you crazy. And I should write another article about mistakes I made or barely avoided myself.
Well, that'll be for our next session. But I thoroughly enjoyed speaking with you, and it's very informative, and I think our viewers will really benefit from your insight and from your publications. And thank you for taking the time for this session of Litigators Corner.
Great to talk to you. Thanks.
Thank you.